Good morning. On behalf of the Florida Bar and the Young Lawyers Division, thank you for joining us on this Friday the 13th. My name is Nikki Freed, and I am an attorney with the law offices of Kolodny, Fast, Tallahassee, Karlinski, Abate, and Webb. I'm delighted to be hosting the Road Less Traveled, Practicing in the Legislative Process, as part of the Young Lawyers Division Luncheon webinar series. Before we get started this morning, just a few housekeeping items. First, as you can all see on the right-hand side of the webinar, there is a dialog box which you can communicate with me directly and pose any questions to the presenters. As time permits, I will pose your questions to the presenters. If your questions are not asked, I will send them directly to the presenters so they can follow up with you directly. If for some reason you do not see the dialog box, feel free to contact me directly throughout the presentation at nfried@cftlaw.com. Second, the CLE course number will be made available at the end of the webinar. Lastly, this webinar is a part of our yearly webinar series that can be found and located and watched at a later time on the YLD website, www.flaYLD.org. Thank you again, and without further ado, I'd like to start off by presenting our first speaker, Jim Doughton. Jim is a shareholder with the law firm of Metz, Husband, and Doughton. Jim practices in the legislative affairs and administrative rulemaking area of the firm, which emphasizes on financial services, technology, and healthcare. Jim serves on the advisory board of the Florida Chamber of Commercial Political Institutes and chairs the Florida Chamber's Free Enterprise PAC. Jim speaks regularly to audiences about Florida's governmental and political environment and recently authored an article for the American Bar Association's Business Law Journal entitled, "You Must Be Present to Win, What Business Lawyers Need to Know About Legislative Advocacy." Jim graduated with high honors from Florida State University and from the College of Law. Jim also received his undergraduate degree from Stetson University. Without further ado, Jim Doughton. Thank you very much.
Thank you, Nikki, and thank you for putting together what looks to be just a terrific agenda. This is the second time I've done this in the last few years, and it keeps getting better and better. One of the reasons I was asked to speak today is because my firm has the honor to represent the Florida Bar before the Florida Legislature, and so they asked me to talk a little bit about some of the policy issues that confront the bar and sort of what we work on during the legislative session. I'm supposed to be tag-teaming this presentation with Paul Hill, the General Counsel of the Bar. Paul had an emergency and couldn't make it today, so I'm going to do both portions of the presentation. The first portion is really going to deal with how the bar develops its legislative positions. And then secondly, I'm going to try to warm you up for the other speakers that are going to be part of this presentation by giving you a quick Government 101 and talk about some specific issues that the bar confronted. The first slide really points out that we're a unified bar, and I think we're having a technical issue moving the slides forward. I think we're in good shape now. So the first, I wanted to start by pointing out that we're a unified bar and telling you a little bit about what that means. It means that we're required to join. It's not a voluntary activity on our part. Florida follows 32 other states in the District of Columbia that have unified bars. And just for what it's worth, we've never had a unified bar move to a voluntary bar. So we're really an all-in-one organization, and really it puts us in a role of being a regulator and a professional association. And sometimes that can lead to a volatile relationship or a volatile management process. And we're going to talk a little bit about how the bar develops its legislative priorities within that context. On slide 2, we are also, following the line of being a unified bar, we're also regulated by the Florida Supreme Court as opposed to other professions that might be regulated, for example, by the Department of Health or the Department of Business and Professional Regulation. But it is constitutional that the Supreme Court has exclusive jurisdiction over us. And because we are required to join and in this unified system and regulated by the Supreme Court, What a unified bar can do in the legislative process is fairly specific. I would also mention before I move to the next slide that not only is the Florida Bar an arm of the Supreme Court, but also the Florida Board of Bar Examiners, which is a second arm of the Supreme Court. A lot of times there's some confusion over when you're applying for bar membership. It's not the Florida Bar that regulates us. It's the Florida Bar that regulates us, but the Florida Board of Bar Examiners is a separate entity that allows us to get in, I guess, if you will. The next slide really helps define what role the Florida Bar can play in legislative activities, and you see there's a Supreme Court rule on the topic, and it really provides a context for the interface that the bar can have with the legislature. And just practically, I want to talk about how that interface occurs. The Florida Bar, if you go to their website, on the left-hand side, it says legislative activity, and you can click on that, and it gives you what the Florida Bar positions are, and has a master list of what not just the big bar activities are, but also the various sections. $5.41 of your $265 dues go towards governmental affairs or legislative activity, and that number is going to be important to you as we follow some of the line of cases that come up next. I also want to mention on that bar website that there are various sections for family law, real property section, business law, and that's a really good place as a practicing lawyer if you're interested in what's going on with legislative activity or newly filed legislation or recently passed legislation. Just to want to know what's going on in your specific professional area, it's a really good resource to just get a quick read of what the new laws and how they're impacting you. So keep that in mind, and you may want to click on that site when the presentation's over. I also want to spend just a few minutes talking a little bit about the case law that has sort of served as a context for what the legislative activities of the Florida Bar can be. The first case is the Florida Bar v. Schwartz, and it really says as much about what the bar can't do as what the bar can do. And I would just point to you some of the restrictions on what bar activity can be, and this all goes back to the fact that we're a mandatory bar. And they're fairly straightforward in terms of questions concerning our regulation, functioning of the courts, the availability of legal services to society. So those are sort of the broad areas. But then, as we go to the next slide, you'll see that there's a little bit more specific criteria. And oftentimes, if a policy position of the bar does not meet those criteria mentioned in Schwartz, there's a second analysis, a more narrowing, that deals with where a lawyer is especially suited by their training and experience to evaluate and explain the issue. So it really has to be very specific to our profession, and also if there's an issue where, as a lawyer, we have particular expertise, then the bar can get called on. The second line of cases is Keller versus California, and that developed around the California Bar Association taking some positions on gun control, nuclear weapon freezes, and sort of a global policy positions, yet they were still a unified bar. And in Keller, the court narrowed what the functions of a unified bar can be. And so far, the Florida Bar positions have developed with these cases in mind. And as a matter of fact, if there's a policy issue which an individual member feels that the bar should not be engaged in, they're entitled to get their $5.41 back of the $265. I don't believe that's happened very often because the staff at the bar and your counsel try to do a good job of making sure what the appropriate role for the bar is as it interfaces with the legislature. And as I mentioned at the beginning of the presentation, Paul Hare was actually going to be doing a lot of these slides. And for those of you who don't know Paul, he's sort of a detail guy, very kind of OCD, if you will, and he, in addition to these slides, presented me some talking points that I was supposed to use for these, the first 7 or 8 slides. I've ignored all of them except for this one on slide 7 when he talks about the sections of the bar, and only because I thought he had a couple of good lines in here. He calls the various sections mini bars within the mandatory bar. In the context here, the hallmark of the voluntary bar or the sections are that it's voluntary membership and it is separate and voluntary funding. And you probably know this as when you get your bar statements at the end of the year, you have the mandatory bar part, but then you can join a section, and that's sort of in addition to what your bar dues are. And for that reason, these sections have a little bit more flexibility as to the policy issues that they can take. The law, as we just heard from the Keller and Schwartz line of cases, is they're very concerned as to whose name people are lobbying in and whose money is being used. So section advocacy is now where a lot of the more pocketbook issues, if you will, are taking place, where the big bar, the Florida bar, is at the sort of higher, more noble, idealistic, and germane matters, because, as I've mentioned previously, we're constricted because we're the unified bar. The sections have a lot more flexibility. How this plays out in the real world, though, is when you're before the legislature, it's oftentimes in the committee or on the House or Senate floor, you'll get a question from a legislature, where's the Florida bar on this? And well, I've just spent 10 minutes explaining to you how what the differences is between what the sections can do and what the big bar can do. Oftentimes that's lost in the fast pace of the legislative session, or when a legislature has a specific question. I have a couple points on that. First, I think we should be proud as lawyers that members of the legislative branch are asking what the Florida bar's position on a particular thing is. They recognize that legal expertise that we provide and look to us as a resource as they develop policy. But we're also, as representing the bar, very sensitive to what those lines can be between what the sections do and what the big bar can do. In the legislative process, you're going to hear later, you typically get a 10 or 15-minute meeting with a member of the legislature to talk about a particular issue. And oftentimes when I go in on a bar issue, I'll be asked about various sections issues. And so I try to explain that, and that takes about 13 minutes of the 15-minute meeting that the legislator is giving me. So I'm going to improve on that as we move forward and try to better differentiate what the sections are up to versus what the big bar is up to. I also want to point out a couple of other logistical items. The Florida Bar has a legislation committee. Its members are listed on the slide there, and it's a pretty good representation from people around the state. Larry Sellers, who's going to be presenting later, is a member of the legislative committee, and they're really the entity that looks at the positions of the big bar and the sections and make sure that they conform to what the rules are. I also want to talk to you a little bit about what the bar's legislative priorities were this past session, and they've historically not changed a tremendous amount over the years, but obviously we're defenders of the judiciary as a co-equal branch of government. We also would get involved in anything relating to admission to the practice of law through the Board of Bar Examiners and any disciplinary issues impacting lawyers. We also recognize the judicial branch, again, to this separation of powers and co-equal branch issue as a proper authority for rulemaking and adopting rules for practice and procedure. We also spend a lot of time working with our partners in the Article 5 area, the courts and the clerks, and our friends at the State Attorney's Office and public defenders to make sure that there's stable funding for the judicial system. And we also support finding dollars to help the poor obtain legal services in the civil area. You probably will see in the bar news or may have read in the paper that President Pettis and incoming President Coleman really started talking about access to courts and recognize that it's not just a lawyer problem but a broader societal issue that the state's going to have to deal with in the coming years. And now I want to turn over to the second section of the presentation. Now that you know how the issues are developed and what those issues are, and then what, as your legislative council, we have to sell, the next few slides describe when we have to sell it and how we have to sell it and to whom. It's really a quick Government 101 overview. If any of you went to Stetson University as an undergrad like I did, it's very much like Dr. Bailey's state and local government class, which I think he's still teaching. But I thought it might be worth a refresher as we get ready for the other presenters to talk about some of the specifics of what they do. A couple of logistical items. The legislative session convenes on March 4th and ends 60 days later. This past year, that was May 2nd. But it's very important to note that we're really not a quaint southern state. Florida is a fairly sophisticated state, and to think that the legislative process is 60 days is not really it's not really accurate. The legislature started in committee meetings last September and spent a week in September, October, November, and December working on policy issues, and a couple weeks in January and 3 weeks in February, all prior to the legislative session commencing. Most of the budget work, or at least the early work on the budget, is done prior to the legislative session starting. Most bills that stand a chance of passing are heard prior to the beginning of the legislative session and are heard in committee. So there's a tremendous amount of activity, and I'm sure the legislators on the call will tell you later that it's the last thing from a part-time job. It is taking almost exclusively all of their time, and you have to really pay attention to it as a year-round gig, if you will. I think Larry's going to talk a little bit about that as well as he talks about the trying to balance a traditional legal practice with a legislative practice. Also, just generally about the legislature, this is back to that state and local government 101 course. There's 120 members of the House, 40 members of the Senate. 47 of the 120 representatives were new to the Florida House this last session. That's a result of legislative term limits, which are 8 years, and 15 of those 40 senators were new to the Senate. I also have the partisan breakup there for you to take a look at. Historically, we've had a lot of lawyers in the legislature, and it's no doubt it's the same for this cycle. There's 32 attorney legislators in the House and 12 attorney legislators in the Senate. I've listed them there for you. I'm sure they're people you know. Many of this pretty well spread throughout the state, and some of them will be participating on this call a little later today. Also, as we moved into the legislative session, I just wanted to highlight some of the above-the-fold issues that if you wake up in the morning and go online or open a newspaper, that you'd read about what the legislature is up to. And I share that just to tell you, to give you a glimpse of the complexity of some of the issues that the legislature deals with. We're a big state. We're a sophisticated state. We and the issues are big and complex. There were 1,800 bills filed this year. Only a small percentage of those actually passed. But it does show that beyond those above-the-fold issues that you'll read about in the newspaper, there are hundreds and hundreds of other important pieces of legislation, all of which take up a great deal of time in the legislature. I'd also mention one of the above-the-fold issues that I think will be talked about a little later on the call were the immigration issues. And there was an issue this session, for example, about how and whether an illegal immigrant who is not born in the United States could be admitted to the Florida bar. So that was an issue the legislature confronted this year, and I think you'll hear a little bit more about. Also, a little bit more on the Government 101. We have a big budget here. It's $77.1 billion. We're one of the top 25 economies in the world. So as I get back to that complexity issue of what the members of the legislature have to deal with, that's not chump change. And we have a few more details to share with you about the budget, specifically the state court budget. You'll see that it's about $501 million. It's just 0.6% of the total. I'm pushing, maybe the legislators on the call can help us bump that up to maybe 1% next year, or at least a little more. But two issues that were really important to the bar this year as we worked with our partners in the courts was a pay package for the Supreme Court employees. what we found, or what the court really found and asked for our assistance with, is that a lot of court employees or employees in the judicial branch were not making, on parity, were not making the same as other state agencies. And so in Tallahassee and throughout the state, you may have an administrative assistant that was moving to another agency job, the same position, because it paid $2,000 or $3,000 more. So really, with the help of Chairman McBurney and Senator Bradley and Senator Negron, we were able to encourage them to bring some pay parity to the court. That was an $8.1 million appropriation. And then also the state's attorneys and public defenders were able to have some retention pay issues addressed to the total of $9.6 million. Again, just trying to make sure that we can keep good employees in the branch. Another issue that the legislature dealt with this year and that the Florida Bar supported was civil legal assistance. I mentioned a little bit about that earlier in the call, but basically it's dollars for legal aid programs around the state to provide low-income residents to help in civil areas, including family law, how to help folks get federal benefits, including veterans benefits, domestic violence, elder abuse, and juvenile law. I think we have a record now. The legislature's done a terrific job of funding that the last 4 years. It's been vetoed the last 4 years as well. So obviously we're going to have to do a better job of educating on that issue and really trying to explain that it's a program designed to help a lot of folks who wouldn't necessarily have access to an expensive and complex court system. Student loans has also been an issue that state's attorneys and PDs have been involved in. As many of you know, it's very difficult to retain those mid-level lawyers once they've practiced for three or 4 or 5 years under the stress that PDs and state attorneys have and the huge caseloads. It's a good time to leave for the private sector sometimes because the money's much better. And so there's been real interest on the part of Representative Waldman and Senator Ring to try and deal with some type of loan forgiveness program or a cash grant, a financial assistance program for PDs, assistant attorney generals, and statewide prosecutors, and to try and help retain those employees. The pay package that we worked on this year does some of that, but I think what Representative Waldman and Senator Ring were most concerned about is a more long-term sustainable program. Another issue that was very important to us and took a lot of time during the legislative session, we had a lot of guidance from Larry Sellers on this, is the ability for state agencies to pay the bar dues of their lawyers. Again, this gets back to the pay issue when you have a junior lawyer not making a whole lot of money in a state agency. Oftentimes, having the ability for that agency to cover that employee's dues is very important. It is not automatically allowable, and so each year we have to go in and deal with the budget and appropriation staff and the chairman to ensure that there's permissive language that lets state agencies pay Florida Bar dues and also some CLE requirements for their employees. And that's always a struggle as we deal with the legislative appropriations process. It's always fortunate, though, when Senator Negron and Senator Bradley and other members who are in the appropriations world recognize the importance of this. So my hat's off to them and to Chair McBurney for helping on that issue as well. Another priority issue for the bar that Nikki, our host, actually spent the bulk of her legislative session working on, it was a tremendous victory and an important issue, dealt with the special needs of children who were accessing the court and had really complex and severe issues and needed the assistance of a lawyer. And so Representative Fresen and Senator Galvano sponsored legislation that Nikki helped work on. It's Attorneys for Dependent Children with Disabilities, and it allows it really requires the court to appoint an attorney for a dependent child when certain diagnoses are made or certain situations arise. And as we talk about those important policy issues and access to justice, this was a very important issue that the bar was proud to support. The next issue was actually one where the Florida Bar opposed. Sometimes, as you might expect, there are certain areas between the branches that need to be sorted out. It's a natural tension between the co-equal branches of government, and oftentimes you're dealing with what the appropriate role of each branch might be. And sometimes, just as in litigation, often you can solve a problem without having to actually file a lawsuit. Sometimes you can solve a problem by filing a bill, but not actually having to pass a bill. Representative Hill and really Chairman Larry Metz and Senator Greg Evers were concerned with unlicensed practice of law, and really, as the court, through its rules, has defined what the unauthorized practice of law is and what roles and responsibilities both lawyers and non-lawyers have. There's a natural tension for the legislature to want to get involved in that. The Florida Bar's position, though, really supported the exclusive jurisdiction of the court to regulate what the unauthorized practice of law might be. And I give a lot of credit to Chairman Metz and Representative Hill in particular, who were able to sit down with members of the bar and also with members of the court to really talk about the issue and vet it out, and hopefully we'll move forward in a positive direction going into the next legislative session. They did pass legislation, however, dealing with community association managers and what their role is in terms of and responsibilities are versus what a lawyer's might be in the condo arena. That was Senate Bill 1496 and House Bill, wrong numbers on that. That's House Bill 7037 that dealt with the CAMS issue. And again, if you use that handy-dandy website that Paul put together at the Florida Bar's website, you'll be able to get an update on all of this legislation. The last slide I have is just some contact information. Paul Hill's information is listed, and then my information is below that. If anybody has any questions or comments about this or any other legislative or policy issues that are going on, we're glad to answer them. And with that, Nikki, I'll turn it back over to you.
Fantastic, Jim. We actually did have two questions that came in through the course of your presentation, but thank you so much. That was very informative. The first question is there is still somebody who is unclear of the difference between the big bar and the section bar as far as their stances on specific bills, how they come up with their agendas.
Sure. So the sections have a lot more flexibility because their voluntary dues are used for them, so they can get involved. And I'll give you an example. The business law section, because of the bar, because it has a particular knowledge and expertise in terms of business issues, might get involved in a rewrite of the Uniform Commercial Code, for example. And there may be interests that don't really like the business law section's position on that, and it's okay to sort of get in a scrap over the legislature on that specific policy issue. Whereas the big bar wouldn't necessarily get involved in a specific business law or real property law or family law issue because we're integrated and our dues are used and we're required to join. We have to stay at sort of a higher level in terms of the independence of judiciary, funding for the judiciary, the role that the co-equal branch of government might play. So I think you'll see the sections, because they have a lot more flexibility to get involved more in the nitty-gritty legislation of a particular policy area.
And just as a follow-up, do you find, because you all represent the actual big bar, does these individual sections have their own lobbyists?
Some of them do. The business law section, the real property section, the family law section are three that come to mind. Some of them don't, however. Some of the sections are smaller, and a lot of times it'll be the members of the Board of Governors or the just the regular section member will call and ask for a specific update on a bill. That's why that website comes in handy too. Paul will try to track all the legislation that might impact a particular section so that they have availability to check what's going on that might impact the international law section or the family law section or real property section or any of the others, government lawyers. So I'd say it's a pretty small percentage of it's usually the larger sections that have outside counsel.
Okay, and lastly, we had another question that came in that asked if the Florida Supreme Court opposed allowing CAMs to practice some area of the law, and is it likely that the CAMs will get such authorization?
Right. So, and this is where I wish Paul Hill were on the call, but I'll explain it to you as I know it. There is an issue pending before the court, I believe, that that relates to the roles that CAMs can play. There was also legislation that passed this past legislative session, House Bill 7037, that provides a little bit of context as to what the roles and responsibility are. But there is an opinion pending before the Supreme Court.
And we actually did just get one more question that came in that asked if there's a reason why the Assistant Attorney Generals were not included in the loan repayment bill, but not included to receive retention pay in the budget.
Read that to me one more time, Nikki.
Sure. The question was, is there a reason why the Assistant Attorney General were included in the loan repayment, but were not included to receive retention pay in the budget?
Yeah, that's a terrific question, and one I need to dig in a little bit more. The substantive legislation that Representative Waldman passed didn't finish through the legislative process, and so and so really the action was where this year was around the funding, and I suspect, and this is where I need to do a little bit more research, but I suspect it's because the Assistant Attorney Generals or Assistant AGs are part of the employee pay package for other state employees, but I need to double check on that.
And we also have Representative Waldman, who will be on the phone call later today, so maybe he can give us some additional insight onto that as well.
Right.
Well, Jim, I appreciate your time this morning, and I thank you very much on behalf of the Young Lawyers Board and the Florida Bar.
Thanks, Nikki.
Now, moving on to our next section, the art of lobbying. It is my distinct honor and pleasure to introduce State Representative Jose Felix Diaz, who was born and raised in Westchester area of Miami-Dade County, the same area that he now represents in the Florida House of Representatives. He is a graduate of the University of Miami and the Columbia School of Law. Since 2005, Representative Diaz has been a practicing attorney with the law firm of Ackerman Centerfit. His practice includes litigation, land use and zoning. Representative Diaz served on the ABA House of Delegates, the Executive Committee of the Board of Directors of the Charlie Home for Children, the largest foster care agency in Florida, and the Board of Directors of the Cuban American Bar Association. In November 2010, Representative Diaz was elected to the Florida House of Representatives. Today, Representative Diaz serves as the chairman of the Florida House Energy and Utilities Committee, and he was recently elected by his peers to serve as the vice chairman of the Miami-Dade Legislative Delegation. In addition, we have Katie Webb. Katie manages the Kolodny Fast Townsend Karlinski Abate & Webb's Lobbying and Governmental Consultant Division in Tallahassee. Katie represents a cross-section of business and public entities, including national and international insurance companies, insurance agencies, and other businesses before the Florida Legislature and executive branches. A recipient of the Outstanding Lobbying Efforts Award from the Florida Insurance Council, Ms. Webb serves as Florida Legal Counsel and lobbyist for the Property and Casualty Association of America, as well as the Florida Property and Casualty Association, a consortium of home, domestic, and insurance carriers. She earned her Bachelor of Science in Political Science in 2000 from Florida State University and her Juris Doctorate from the Florida State University College of Law in 2003. We also have, in addition, Donovan Brown, who is the Counsel for State Government Relations for the Property and Casualty Insurance Association of America, PCI, who handles all aspects of state government relations for PCI in Florida, Alabama, and Mississippi. An experienced attorney, Mr. Brown has spent a decade in government and law. As a former associate in a major law firm, he counseled and represented clients on matters pending before the Florida Legislature and state executive agencies, especially the Florida Office of Insurance Regulation and the Florida Department of Financial Services. Prior to his legal career, he served as special assistant to former Governor Jeb Bush. He also held the position of Deputy Chief of Counter-Drug Law Enforcement in the Governor's Office. Donovan is a graduate from the University of Florida's Levin College of Law and also earned his Bachelor of Science degree in Business Administration from the University of Florida. He has also been named to Florida Trend's Legal Elite as an up-and-coming attorney. Welcome to the presentation, guys.
Thank you. Thanks, Nikki.
Katie, I want to kind of start off, we heard our first part of the presentation kind of outline some of how the Florida Bar creates their legislative agenda and some of the aspects dealing with attorney regulations and dealing with lobbying. Katie, can you tell those who are on the phone, what exactly do you do as a lobbyist?
Well, that's $1 million question, Nikki. Thank you very much. So the day-to-day functions of a lobbyist really are different each and every day you go to work, and cyclical in nature in terms of the time of year. What we're doing now that the legislative session is over is concentrating on creating financial support for legislators and other elected officials with whom our clients share a lot of philosophical ideas and positions with. We also, during this time of year, do a lot of client management and client relation type of activities, meaning we are visiting clients across the country and all across the state of Florida. We are doing a number of presentations for the clients to discuss with them what occurred during the legislative session, how it might impact them, how they may be able to take advantage of certain things, and how we may be able to continue to help them through any kind of rulemaking or regulatory process that is basically started or was instigated by a legislative measure that passed. And then as we move into the fall, obviously with campaigns heating up, we will likely send different members of our legislative team to support specifically specific candidates with manpower, with walking around, knocking on doors, sign waving, things like that. And post-election, when the committee process starts again, and after the organizational session, when committees are assigned and the legislature starts meeting again, we will get more into the traditional aspect of lobbying, where we are tracking legislation, developing legislation, going to committee meetings, providing feedback to legislators on different proposals, and really getting to the nitty-gritty of lobbying, of sitting with legislators and discussing with them our clients' positions on certain issues, and hoping that they will support our clients in terms of what their initiatives are during the legislative session. And it will really be that as our primary function until the legislature adjourns, and which would be next spring. So it's kind of a cyclical type of process, and every day is a little bit different. But that also makes it a lot of fun.
Is there something that you believe in your time as a lobbyist that makes you an effective lobbyist?
Well, I mean, I think one of the cardinal rules for really all lobbyists and really all lawyers in general, but specifically for lobbyists, is you've got to create a very trustworthy reputation and a trustworthy rapport with a lot of legislators. The legislative process is one of these processes that can really heat up and move very quickly in a fast and furious type of way. So oftentimes, when you are discussing issues with legislators, you have to be very, very careful to be as honest as you possibly can and explain to legislators, your client's positions, advocate for your client, but also disclose to them if they're going to be walking into any like landmines or any big traps in terms of controversy or opposition to your positions. And if you are not effective in doing that and you wind up getting a legislator in trouble, or if you misrepresent something to a legislator, and eventually what usually happens is people who do that regularly, they always wind up getting caught. But the next time you go see these folks, they're not going to be as quick to believe you, and or you may damage irreparably damage a relationship with some of these people. So I would say one of the very key things that really every lobbyist needs is they need to be known as a trustworthy source of information, because things happen so fast. Legislators are going to have to trust you that you're not guiding them into a complete war zone. So that would be, I would say, the number one thing.
Representative Diaz, what do you see, thank you again for participating today, what do you see as the role of the lobbyist in the legislative process?
Thank you, Nikki, for inviting me. I wanted to start off by saying that I have a unique perspective, not only because I'm also a lawyer, but I actually figured out what the legislature was because I was doing policy work as a lobbyist at my law firm in Tallahassee for a year. And I really fell in love with the process. So I've served, the lawyer role, the lobbyist role, and now the legislator role. And, the topic here is the art of lobbying. And I think there's four types of lobbyists. There's the first, which I think is the relationship lobbyist, somebody who is not terribly substantive, but they do have great relationships, and those folks get hired all the time, and they're not always very effective. There's a second group of lobbyists which are very, very substantive, and a lot of these are lawyers that don't really lobby, but they really know their stuff, and they go to Tallahassee and they try to change laws, and I wish they were more effective, but because they have no relationships, they're not that effective. The third type of lobbyist is, I think, the best type of lobbyist, which is somebody that has relationships but is also very substantive. I think it's, easy to go from the second one to the third. It's not easy to go from the first to the third. And those are really the titans of the lobbying industry. They're very smart people that truly understand their issues, and they've built trust, like Katie was mentioning, in a very prolonged period of time, and they have the ability to really effectuate change. And then the fourth type is the ones that are neither substantive nor have relationships, and there's a bunch of these in Tallahassee, and they're just the worst type of lobbyists. They have one or two clients, and they go up there and they run around in circles and don't accomplish anything for their clients. And at the end of the day, the moral of the story is, as lawyers, and there's almost 1,000 lawyers on this call, you have one of the most important parts of lobbying already figured out, which is your substantive, or you have the ability to be substantive, and that is so important for guys like me when we're making decisions. People forget that in Tallahassee, in a 60-day period, our legislature reviews north of 2,000 bills, and less than 10% of those pass. And the only way that somebody like me, that's a lawyer, I deal mostly in local government and land use law, the only way that I can learn about complicated healthcare issues or insurance issues is if somebody sits down with me that presents a succinct, an honest view of where they see the issue. And I'll sit down with both sides and make a determination. And sometimes if I am having difficulty figuring out which is the better side, I'll call, neutral third parties or folks that I know that, practice a particular industry, and I ask them about the issue at hand, and they help me figure it out. But if you want to be an effective lobbyist, you have to know your stuff. And a lot of firms, I know there's several folks on the call that work at the Kalani firm. They are mostly an insurance lobbying firm, and there's a lot of groups that try to focus mostly on one area. Those firms get a very good reputation as the go-to source for certain bills, and legislators know what to call on them. So if you want to be good, know one area, know it very well, know it better than anybody else. And in the meantime, try to build some relationships with key legislators so they can help fix the laws that need to be fixed.
And kind of to follow up on that with Donovan, as somebody who is in-house in a trade association, how have you gone around to hire your contract lobbyists?
Thanks, Nikki. And first, let me thank Representative Diaz and Katie for being on this panel, and those 1,000 attorneys. I know there's a lot of folks that were attending the CLE today. I'll just take off right exactly on what Representative Diaz said. He hit the nail on the head. I look for that third category that he laid out, the effective lobbyist. He's dead on. You have a lot of folks in this town in Tallahassee who have deep relationships, sometimes with a couple of legislators, or they might have a lot of relationships with a lot of legislators. And you do have that second category where you have substantive folks, and typically you see them more in the background or working behind the scenes providing info. But it's truly that third category that you look for, and those are the effective lobbyists, and those are the folks who I look to hire. And, you know, I have kind of a unique perspective here, I guess, on this panel because I was fortunate enough to practice and do some lobbying and regulatory work when I was with Representative Diaz at Ackerman. And Katie is one of my hired lobbyists, and so before when she was talking about relationships and are you a good lobbyist, I think she should have answered directly yes, and Representative Diaz I know would just back that up. But that third category, you want somebody when you look to hire up that has relationships, that has built the trust that Katie talked about with legislators, because it's absolutely imperative that you have that. A legislator needs to know that not only will you provide them good information on a timely basis, but that as you do it from a policy standpoint, you're not going to guide them into a war zone or over any landmines. And that's something you have to be cognizant of. Even if you're with a trade association, as I am, and I focus more on insurance, you need to globally know the politics of the forum in which you're operating. So if I or Katie were to sit down with Representative Diaz to discuss an insurance issue, you better know exactly what's going on also during the 60 days here in session, whether it be with education or the budget or other issues, because all of those ultimately fold into the broader topics, and they can overlap and touch on each other, so that's always very important. And then, again, you absolutely have to have substance. As Representative Diaz, as he said, you go to the parties. Sometimes you'll have factions on one side of an issue or another. You're getting information. You need to go to a third party. You want to hire a lobbyist that has established themselves as knowing the substance and being able to provide information, because those are ultimately going to be the most effective lobbyists that will push the ball forward or move it down the field for you as best you can. So I look to hire those folks that can do exactly that for me.
And Donovan, what is the main difference do you see as your role as in-house lobbyist versus the contract lobbyist?
Nikki, great question. I spent 6 or 7 years at a couple different large law firms here in Florida doing regulatory work, and always being in the lobbying world, I think based upon my former work with Governor Jeb Bush and others. There's really kind of two main types of, if you want to call them in-house lobbyists. I think one is the type that has a single corporate entity, somebody in-house for a corporation, or, whether it be a nonprofit or other type of organization along those lines. Or what you have a lot of here in Tallahassee is the trade association, which I am. And the big difference, and I truly didn't know it, I was a hired gun, and when I came in here, you think you're trading out a number of clients that you do specific work for them on for a larger, broader association where you have basically one boss. And that's not really true, because as I stepped into PCI, we're a national trade. We're in 50 states. We have 1,070 member insurance companies, and I have hundreds of companies that operate here in Florida. So you're working for all of them at once, trying to provide policy guidance and work with them to set a legislative agenda, and then you're working with your lobbyists to try to and maybe you have many lobbyist organizations working with you or for you, to carry out and to implement that policy and to work it through the legislative process and the regulatory process. And one of the biggest elements of that, I have to say, is, and I always knew this was there when I stepped into the trade world years ago, but you always have to be extremely cognizant in trade world of antitrust compliance. And it's not something you think of on a daily basis, and I truly didn't. But as trade associations, you're committed to promoting competition, but you're a favorite target of government prosecutors and antitrust plaintiffs' lawyers, and that's true for several reasons. You provide contact among many members and competitors. You have meetings that involve discussion of sensitive topics. Members are those deep pockets that you always learn that you go for in those types of suits, and an association and its members can, in effect, be found liable for penalties and damages. So, in the trade world and as an in-house corporate type person, you deal with these broad issues, and you're dealing with a lot of, from the trade perspective, with a lot of members. And I got to say, you saw Jim presented earlier on those above-the-fold issues. One of the things I really like is you step into the world where you handle these big issues. I mean, most people on this phone have heard of Citizens Property Insurance Corporation, auto reform like PIP. This year we had flood legislation. That was Jim's one of his above-the-folds. We're involved, I am, from a trade perspective, in all of those types of issues. And the other thing is you come up and you learn your ethical canons, and I see later it's going to be interesting, the substance of what you have on this agenda, where you have Daniel Norby presenting and Larry Sellers presenting. That's going to be kind of the meat of these issues. But you learn, I always thought as a private lobbyist, you perform your job and you do really well when you're not in the press. Well, it's opposite. When you're a corporate or trade association rep, we want to be in the press, and we want to use communications and public affairs to help drive our agenda and to support those like Representative Diaz or others that support our agenda as well.
Fantastic. Representative Diaz, is there one bit of advice you'd give to those who are listening as far as any of the pet peeves that you have seen that you would suggest to not do if they came to see you in Tallahassee?
There's a lot of lobby malpractice that goes on in Tallahassee. A lot of people make a lot of stupid mistakes. I mean, it's obvious, the same as you would in your normal practice of law. You have to be honest. People lie all the time. They overpromise. They'll use one legislator against another and say, well, Representative X said they'll support this issue if you do, and then you go to Representative X and they say, well, they told me that you were going to support it. So, people get discovered all the time. The legislators do speak to each other. Government officials speak to each other. So, you always want to be just completely forthright. You don't want to hide the ball. You don't want to, keep an argument away from the discussion. I mean, the other side is going to come and meet. So you can't pretend that an issue that is an issue is not an issue. Just be yourself, learn your stuff, do your homework, and you'll be fine.
Fantastic. And Katie, any last words of lessons that you'd like to pass on from your experiences?
Oh, gosh, I probably have a lot of mistakes that I've made that I've learned from for the time that I've been doing this. But just one piece of advice, again, would be that, the more substance you can learn in a particular subject matter area, the better off people are and more reliable than you appear when you're meeting with prospective clients and legislators and all that. So know your stuff.
Well, fantastic. And, again, I appreciate you all calling in today. Thank you.
Thank you
so much.
Thank you. Moving on to our next presentation, what is JAC? Presenting that will be Ana Cristina Chris Martinez, who is the General Counsel of the Justice Administrative Commission. Prior to working at JAC, Chris served as an Assistant General Counsel at the Florida Department of Education. Her legal experience also includes service to the Legislative Committee on Intergovernmental Relations, on the Constitutional Revision Commission, the Attorney General's Office, and as a former clerk to Justice Ben Overton of the Florida Supreme Court. Chris is a graduate of the University of Florida's College of Law. Welcome, Chris, to our presentation.
Thank you, Nikki, and thank you so much for giving us the opportunity to make this presentation to the Young Lawyers section. JAC certainly appreciates this opportunity to address the Young Lawyers Division and to let them know who we are and what we do, JAC, or the Justice Administrative Commission. Moving right along, JAC was created in 1965, shortly after Gideon versus Wainwright, and the main purpose was to provide administrative services to the courts, the state attorney's offices, and the newly created public defender's offices. And what that means is basically that we provide these services for these offices in the areas of accounting, budgeting, financial services, and payroll. In 1984, services for the courts were placed under the Chief Justice of the Florida Supreme Court, and OSCA was created. And since then, other entities have been added to JAC's fold, and they include the Capital Collateral Offices, the Guardian Ad Litem Office, and the Office of Criminal Conflict and Civil Regional Counsel. All in all, JAC serves 49 different judicial-related entities. And in 2007, after Revision 7 passed and was implemented, where the state undertook the payment of court-appointed counsel, the task of contracting with and paying court-appointed counsel and other related vendors was also assigned to JAC. JAC is led by a commission, which is constituted of 2 state attorneys, the Honorable Brad King from the 5th Circuit and the Honorable Jerry Hill from the 10th Circuit, and 2 public defenders, the Honorable Diamond Liddy from the 19th Circuit and the Honorable Nancy Daniels from the 2nd Circuit. And these officials are selected by their respective associations and serve for 2-year terms. However, they are allowed to exceed the 2 years and constantly do get reappointed. Last year, after only being in existence for almost 45-plus years, JAC went through its first strategic plan process and adopted its first ever mission, vision, and values, the crux of which is to be responsible stewards of your taxpayer dollars, because that is what we use to fund and pay for all the services related to access to courts. This slide represents our base budget, which is about $817 million. The majority of the budget goes to the state attorneys and the public defenders to support them. And then another aspect of our budget is that which goes to pay for court-appointed counsel and related due process vendors. This slide shows you all the entities that we serve and the services that we provide for them. And these services basically at the end of the day, JAC performs approximately over 370,000 financial transactions for these offices every year. As was covered earlier in the presentation, some of the legislative bills that affected the state attorneys and the public defenders was the salary increase for the state attorneys and the APDs, and also for the regional councils, mentioned by Mr. Metz earlier in the presentation. The permissive state payment of Florida bar dues and CLEs, that affects all the many attorneys that JAC serves, and also the mandatory ethics trainings for state and local government officials. Court-appointed counsel. JAC also serves over 1,700 court-appointed attorneys and over 800 due process services vendors. These include court reporters, investigators, and expert witnesses. Part of what JAC does is that JAC contracts with these persons. We audit and review their bills. We participate in hearings dealing with fee payments. And we also monitor and report how the money is expended to the legislature. All in all, JAC pays over 50,000 bills in this realm. This slide shows attorneys how to become a court-appointed counsel by becoming a member of their registry and signing a JAC contract and then accepting appointments. Bills affecting court-appointed counsel this year was in the GAA, the rates set for compensating court-appointed counsel were raised in certain criminal case types, and you can find the new rates, which will become effective for appointments after July 1st on JAC's website, which is www.justiceadmin.org. Another bill which will also affect court-appointed counsel is the bill spoken of earlier, or where there will be where it's authorized for state compensation of attorneys representing children with special needs, or House Bill 561, which Nikki worked so diligently on. JAC, in consultation with GAL, has been tasked with putting together the registry for these types of attorneys, and those attorneys that are interested in becoming part of that registry can find the registry application also on JAC's website under registries. Lastly, the legislature eliminated the court-appointed counsel limited registry, which had been in effect for the previous 2 years. So now court-appointed counsel registries will now return to the general registries, which was basically the format that they existed for many years prior to that. And JAC just recently in the last 2 years, in an effort to communicate better with court-appointed counsel and also the due process vendors that it served, put together its first JAC newsletter, which you can find on our website under JAC Top Searches, and it summarizes the legislative changes that affect the court-appointed counsel process and other helpful hints for court-appointed counsel to navigate the sometimes challenging aspect of being paid by the state for services that have been performed. But it's our effort to get the information out there so that we can serve court-appointed counsel and the state attorneys and the public defenders and the regional counsels as best we can. Pretty much the last slide here is my contact information. If anybody has any questions or comments, I'm happy to be contacted. And thank you so much, Nikki, for the opportunity to speak.
Thanks, Chris. We did have one question that came in.
Sure.
Able to address. The question is, who oversees the judges who are chosen to be appointed, and why is it left solely to the discretion of the judge for the appointment?
The chief judge is in charge of putting together the registry, and each circuit has a very different process for that aspect. But 2 years ago, the legislature changed it to where there is a designated judge that hears the fee hearings. And who oversees the designated judge? Well, I guess the best answer to that would be the appellate court. If the attorney feels that the fee judge made a mistake in the manner that they were compensated, then they file a petition for writ of cert to the appellate court, and they review it pursuant to case law.
Fantastic. Well, Chris, I appreciate your time today. Thank you. And
thank you.
Working with you in the future.
I'm looking forward to it.
Thank you. Our next presenter is Daniel Nordby. Daniel is the General Counsel of the Florida House of Representatives, where his practice focuses on constitutional litigation, legislative procedure, and ethics election law. Before joining the Florida House of Representatives, Mr. Nordby served as General Counsel to Florida Secretary of State. Mr. Nordby is a graduate of the University of Florida, where he was awarded a Bachelor of Arts in Classical Studies, a Bachelor of Science in Microbiology and Cell Science, and a Juris Doctor with high honors. He is the Chair-elect of the Florida Bar's Administration Law Section. Thank you, Dan, and I appreciate you being on today.
Good afternoon, and thank you, Nikki and the Young Lawyers Division, for inviting me to participate in this program. I'm having a slight technical difficulty with the slides, but I understand they'll be advanced when I ask someone to advance to the next slide. My name is Dan Nordby. I'm the General Counsel for the Florida House of Representatives, which is one half of another of the co-equal branches of state government. I was asked to provide today an overview of some of the legal and ethical issues involved with lobbying the Florida Legislature as a member of the Florida Bar. This is going to be necessarily, in 25 minutes, a high-level treatment of these issues, but hopefully you'll get enough of a flavor of them to have a sense of what's involved so that you can seek out additional information as needed. So if we'll change to the next slide, please. I've broken down my topic into three principal areas. The first one's lobbyist registration and reporting requirements. Next is lobbying restrictions that are imposed by statute. And the final one is lobbying restrictions that are imposed by the Florida Bar's rules of professional conduct for those lobbyists who are members of the Florida Bar. The next slide, please. The first area I want to talk about is the lobbyist registration and reporting requirements. To go to the next slide, I'll start this discussion with the policy behind the lobbyist registration and reporting requirements. The purpose of these requirements is actually set out in statute. There's an enacted statement of legislative purpose in Section 11.044 of the Florida statutes, and this was put in many years ago. And what it essentially states is that the registration and reporting requirements try to strike a balance between the people's First Amendment right to petition their government for the redress of grievances and the preservation of the integrity of the decision-making process that government undergoes. And the way that Florida has tried to balance those two interests is laws requiring registration of those who lobby the Florida Legislature and reporting of compensation that those lobbyists receive for their lobbying work. So the next slide has an overview of the registration requirements for legislative lobbying. And those requirements are found in two principal places. The first is Chapter 11 of the Florida statutes, and the other is Joint Rule 1, adopted by the Florida House of Representatives and the Florida Senate at their organizational session every 2 years. The basic registration requirements haven't changed in a while, and the basic requirement is that all lobbyists register with the legislature's Office of Legislative Services for each principle they represent before they begin to lobby the legislature. So the fundamental question there is, who's a lobbyist? Well, the definition of a lobbyist is somewhat circular. A lobbyist is a person who is paid to lobby. The compensation requirement is important there. If you're not being paid by some client, or if you're not employed principally for governmental affairs by some person or entity, if you are simply talking to legislators about an issue that you believe in for no compensation, you're not required to register as a lobbyist. But if you're being paid by a client or by your employer for governmental affairs to lobby the Florida Legislature, then you are by definition a lobbyist. So what is lobbying? By statute, lobbying is influencing or attempting to influence legislative action or non-action through oral or written communication, or an attempt to obtain the goodwill of a member or employee of the legislature. So you've already heard today a little bit about the Florida Bar's work in lobbying on particular issues during session. You'll notice the definition of lobbying includes both influencing and attempting to influence, even if you're not successful. And it also refers to both legislative action or non-action. Oftentimes, lobbyists are hired to try to make sure the legislature does not act in a particular area, and that too is lobbying. The goodwill aspect of the lobbying definition is something that jumps out to a lot of people who are seeing it for the first time. If you are being paid by someone to try to obtain the goodwill of a member or employee of the legislature, that too falls within the definition of lobbying. It's certainly not prohibited, but it may be something that requires registration as a lobbyist. And as we'll talk about later, it also triggers some expenditure prohibitions under the Ethics Code. So if you go to the next slide, the actual registration form for legislative lobbyists is fairly straightforward. It's a two-page form that's available on the legislature's website, and the second page is essentially nothing more than a notarized signature. The first page requires basic information, the name, the address information for the lobbyist who's registering, the principal that he or she is representing, and if there's a lobbying firm with which that lobbyist is associated, the lobbying firm needs to be disclosed as well. This form has to be filed before lobbying for that principal. So if you are entering the lobbying arena and someone calls and immediately wants you to get over and lobby on something in front of a committee meeting, the law requires this form to be filed before actually testifying or lobbying for a client for compensation. There's also a small, relatively small compensation fee, registration fee for legislative lobbyists, $50 for the first registration of the year and $20 for each additional principal that's being represented after that. So the next slide. Well, I'll mention on that last slide, you can go to the next slide, but the lobbyist registration is effective for a calendar year. It's on a calendar year basis rather than a legislative session basis. The final document required in order to begin lobbying the Florida Legislature is a written authorization to represent a principal. And this, too, is a short one-page form. providing written authorization and a signature from a principal's representative that the lobbyist is authorized to represent that principal. Requires, again, a short statement of lobbyist name, principal's name, a signature, and an industry classification code for the principal's industry. And a link to all of those classification codes is available on the legislature's website. So if you'll go to the next slide, the next topic is something that doesn't have a ready analog in the non-lobbying legal world, reporting of the compensation that your clients are paying you for the work that you're doing. This is public registration and public reporting of compensation. Lobbying compensation is reported on a quarterly basis, and each compensation form has to be filed no later than 45 days after the end of each calendar quarter, reporting the name, address, and telephone number of the lobbying firm, registration name of each of the firm's lobbyists, the total compensation provided or owed to the firm from all principals that the firm represents, as well as a breakdown of compensation provided or owed to the lobbying firm by each principal that that firm represents. And those compensations are not reported down to the dollar. There are specified ranges of compensation. So compensation of between $1 and $49,999 might be an example of a range, or compensation over $250,000 might be a range. So it's within those ranges the compensation has to be provided for each principal, and then the overall compensation of the lobbying firm. The lobbying compensation for reports are filed electronically, and they have to include a certification by the lobbying firm's senior partner, officer, or owner as to both the truthfulness and completeness of the information that's provided. One thing to note from this past session, the legislature's Joint Legislative Auditing Committee announced some procedures for independent random auditing of lobbyist compensation reports. There has been a requirement in statute for a few years now requiring the legislature to randomly and independently audit lobbyist compensation reports. This past year, that process was revived and kind of kicked off. So those independent auditing reports will commence in 2015 with a review of calendar year 2014 compensation reports filed by lobbying firms. And so what the audits will address is essentially just the compensation reports. It's not a full audit of the lobbying firms, but just back-checking the information that is reported on the compensation reports. So you'll go to the next slide. It's just a title slide for the next topic that I'll address, which are some of the legal and ethical restrictions that apply to people who have registered as legislative lobbyists. And the two significant ones that I'll talk about are the lobbying expenditure ban, commonly known as the gift ban, and some contract restrictions that apply to lobbying contracts. To go to the next slide, the first topic here is the lobbying expenditure ban, or the gift ban. This was enacted in 2005, so it's been around almost 10 years now. And what it provides is that no lobbyist or principal shall make, directly or indirectly, and no member or employee of the legislature shall knowingly accept, directly or indirectly, any expenditure except floral arrangements or other celebratory items given to legislators and displayed in chambers the opening day of a regular session. So it's a fairly short prohibition, and it's even shorter if you pass over the floral arrangements aspect of it. No lobbyist or principal shall make, no member or employee of the legislature shall knowingly accept, directly or indirectly, any expenditure. So it's a fairly flat ban of expenditures from lobbyists or principals to legislative members or employees. If you go to the next slide, what's an expenditure? An expenditure is a payment, distribution, loan, advance, reimbursement, deposit, or the catch-all, anything of value made by a lobbyist or principal for the purpose of lobbying. So there is no de minimis exception here. Members and employees of the legislature may not accept anything of value from a lobbyist unless there is a particular specific exemption that applies that allows the member or employee to accept that item. The no de minimis exception here oftentimes is referred to as the no cup of coffee exception too. So a lobbyist may not buy a cup of coffee at Starbucks for a member of the legislature if they're meeting there to talk about lobbying issues, or even not to talk about lobbying issues. Even if a lobbyist and a member are longtime friends, they should go Dutch treat. The next slide has a few of the exceptions that have been identified to the lobbying expenditure ban. Gifts received from relatives are not subject to the ban, so if a member of the legislature has a relative who is a lobbyist or an employee of the legislature has a relative who's a lobbyist, they can accept a birthday gift or Christmas gift, so forth. Members of the legislature who are employed by lobbying firms, and there are a few of them, can receive their salary. That's not prohibited. Contributions and expenditures that are reported under state or federal campaign finance law are exempt. A few other items, personalized plaques and certificates. Certain types of expenditures associated with free and open public events at the Capitol in Tallahassee are exempt. There are a few, during the session, a few lobbying principals traditionally have events at the Capitol to promote their activities. Miami-Dade Days is one of those. Other professional associations have events like that, and if they're held according to certain conditions, then employees and members of the legislature can go and partake of a food or other things along with other members of the public. The floral arrangement exception I already mentioned. And of course, if the legislative employee or member pays for the item they're receiving from a lobbyist or a principal, then it's not an expenditure, it's not a gift if they're paying the equivalent or greater value within a contemporaneous time period. So if you go to the next slide, I want to touch on a couple of lobbying contract restrictions. One of them that's of interest to a lot of lawyers is the contingency fee prohibition. Lobbying contracts cannot be dependent on, cannot be contingency contracts. They cannot be contingent on the enactment, defeat, modification, or other outcome of any specific legislative action. And there's actually a criminal penalty for a lobbyist who enters a contingency fee contract. The fee is subject to forfeiture, and there's a first-degree misdemeanor that applies to it. There is an exemption for claims bills. So a claims bill is a particular type of legislation that seeks compensation for oftentimes some sort of a personal injury or other alleged wrong done by the state to someone for which the recovery would exceed the state's sovereign immunity limits. So the contingency fee prohibition does not apply to claims bills, but it does to any other type of legislation that might be considered by the legislature. So if you go to the next slide, another lobbying contract restriction is a prohibition on the use of state funds for lobbying. Lobbyists who represent state entities and government entities will need to make sure they carefully construct their contracts with this provision in mind. This doesn't apply to full-time employees of state agencies or universities, for example. They can certainly lobby the legislature. If you go to the next slide, the final area that I'll talk about is lobbying restrictions imposed by the Florida Bar's Rules of Professional Conduct. Now, the Bar's Rules of Professional Conduct don't directly address lobbying with any specificity, but for lawyers who also lobby, the Bar's Rules of Professional Conduct apply to their lobbying activity as well as their more purely legal activity. To go to the next slide, the Bar's ethics staff has opined in an article that's posted on their website that in almost all instances, the rules of professional conduct in Chapter 4 of the rules regulating the Florida Bar apply to lobbying activity of a lawyer who engages in lobbying. And I have a link to that entire article there on the slide. It's a useful article that the Bar published and I think is updated since the new lobbyist disclosure statutes were enacted 8 or 10 years ago, but it has a good question and answer format of how the bar generally views some of these issues. If we go to the next slide, the confidentiality of client information that's contained within the bar rules regulating the Florida bar applies. A lawyer must not reveal information relating to representation of a client unless a particular exception applies, like the lawyer is going to be committing a crime, or if the client gives informed consent. So how can a lawyer who is a lobbyist comply with the lobbying disclosure requirements that I talked about earlier, reporting compensation and so forth? Well, the answer is that a lawyer or lobbyist has to obtain informed consent from each client as to the disclosure of that information that must be reported by law. So in constructing an engagement agreement for lobbying services, one thing that a lawyer or lobbyist needs to be aware of is to obtain their client's informed consent that they will have to, by law, disclose the compensation that they'll be receiving from that client for lobbying services. And that article that I referred to on the last slide has some good information and tips there for how to comply with this provision, suggestions on segregating lobbying and non-lobbying activities that a lawyer or lobbyist might do for a client in order to make that reporting easier and to ensure that nothing is disclosed which should not be disclosed. The next slide addresses the conflicts of interest provision in the rules regulating the Florida bar. Unlike lobbyists who are not attorneys, lawyers who lobby are subject to the conflict of interest provisions that are in the rules of professional conduct, and will need to be aware of those in deciding whether or not they may lobby for particular clients whose interests may be adverse to one another. So this puts lawyer lobbyists at a bit of a disadvantage in some aspects of trying to seek out and obtain new clients, because if clients' interests are adverse and that conflict isn't waivable by informed consent, then a lawyer can't represent those two separate clients, whereas a non-lawyer lobbyist sometimes can represent clients with adverse interests, subject only to, I guess, their own personal ethical standards, reputational concerns, and so forth. So when considering representation of lobbying clients whose interests may be adverse to one another, a lawyer who lobbies should make sure that he or she reviews the informed consent requirements in Rule 4-1.7 of the rules regulating the Florida bar, and perhaps talk to the bar's ethics staff, too, if there's a particular question. So the next slide is just my conclusion with my contact information. I'll be glad to answer any kind of specific questions that anyone might have at the phone number there, subject to, of course, the constraints of my current job. I can't provide legal advice to anyone other than the Florida House of Representatives and its members. But if there's something generally that someone wants to talk about, I'd be glad to talk about that or answer questions on the call.
Thanks, Dan. We did have a couple of questions that came in. The first one is if you can please further define the requirements for registering as a lobbyist. For example, if an individual is employed by a Florida nonprofit organization and a small, less than 50% of their work includes speaking to legislators about pending legislation on an issue advanced by that nonprofit organization, would that employee have to register as a lobbyist?
It's a good question. The for-profit or nonprofit status, I don't think makes a difference with the definition of a lobbyist. I think what I would look at on that one is, I think under the hypothetical that you gave, the person less than 50% of their work would be involved in governmental relations. The definition of a lobbyist includes a line that says a person who is principally employed for governmental affairs by another person or government entity. So if the person is not principally employed, if that's a small part of what they do for the employer, there may not be a requirement that that person register as a lobbyist. I should have mentioned earlier, one other resource that someone can use if they're interested in this is the Office of Legislative Services, which is a branch of the legislature their general counsel is empowered by the joint rules of the legislature to offer informal opinions to anyone who has a question about how the lobbying registration and reporting rules may apply to them. So you can contact the general counsel of OLS as well if you need an informal opinion, and you're entitled to rely on that opinion if you follow it.
And another question, thank you, another question that came in, is the compensation to be reported only compensation paid for lobbying, or would include all fees paid by the client to the lobbyist, even if some of the compensation was for legal, accounting, or other non-lobbying advice or assistance?
Okay, that's another good question. The compensation that has to be reported is compensation for lobbying work that is done for that principal. And that's one of the aspects of the auditing guidelines that the Joint Legislative Auditing Committee has adopted last session, is trying to make sure that that lobbying expenses are being reported and not non-lobbying expenses. So if you're doing both legal work for a client and lobbying work for that client, it's the lobbying compensation that has to be reported, not non-lobbying compensation.
Okay, next question, are the compensation disclosure requirements applicable only to firms and not as it relates to in-house counsel who also lobby on behalf of their own, his or her employer?
Any lobbying firm that represents principals before the Florida Legislature has to file compensation reports identifying the amount of compensation that's received within those ranges.
And lastly, what penalty is there if someone should register but does not?
Well, there are a few penalties. Well, let me mention first, there are penalties for not filing or late filing compensation reports. There's a fine that can accrue, and on the recommendation of the Office of Legislative Services, the presiding officers of the legislature can impose a ban on lobbying by that person for a certain amount of time. There are also, for someone who should register but doesn't, there's also a complaint procedure that's in the rules of the House of Representatives and the rules of the Senate. If a complaint's received, it can be acted on by a legislative committee, and there can be public censure, a ban from lobbying, fines, and other penalties like that imposed on someone.
Well, Dan, I appreciate your time today. Thank you very much.
Thank you.
Moving on to our next presenter, Larry Sellers, who we've heard about numerous times already on this presentation. Larry is a partner at Holland & Knight in their public policy and regulation practice, where he practices environmental and administrative law. He has represented clients before the Florida Legislature since 1985 and in administrative licensing, enforcement, and rulemaking matters since 1980. Mr. Sellers is a past chair of the Florida Bar's Environmental and Land Use Law Section. He is a past president of the Tallahassee Bar Association and a current member of the Florida Bar Board of Governors. In addition, he is a Florida Bar Board certified state and federal government and administrative practice lawyer. Mr. Sellers is listed in the Best Lawyers in America Guide from 2005 to 2014. The Chambers USA America's Leading Business Lawyers Guide from 2008 to 2013, and Florida Legal Elite from 2005 to 2013, and Florida Legal Elite Hall of Fame from 2009 to 2013. He is a member of the Florida Association of Professional Lobbyists. Larry, welcome to the call.
Thanks, Nikki. Appreciate you including me in this program. It's been excellent so far. It's some big shoes to fill following all this great presentation. Nikki asked me to talk a little bit about the how do you successfully bridge the gap between government consulting and the practice of law. And she asked me to address this really by focusing on a handful of questions that I think will help at least guide the discussion. Starting with the question you always get, how did you get into this line of work? I actually sort of fell into it. I had been practicing environmental law and land use law with a Holland & Knight firm in our Tampa and Lakeland offices for about 5 years when I moved to Tallahassee many years ago. Much of my legal work was for a number of large phosphate companies, advising them regarding numerous regulatory requirements, and helping them get various environmental permits and land use approvals. All of these companies were members of a trade association, the Florida Phosphate Council, that had two very experienced in-house lobbyists in Tallahassee. In-house lobbyists of the time were very knowledgeable about the legislative process, and they enjoyed very good relationships with key legislators. But the law being complicated, they often turn to their lawyers to help them review and evaluate and even write proposed legislation. In my first year in Tallahassee, the legislature was considering major changes to Florida's growth management law, and this client asked me to help his lobbyists by reviewing the proposed legislation and recommending any necessary changes. This also involved accompanying these in-house lobbyists and attending the many committee meetings as well as meetings with individual legislators. Following them around in turn allowed me to learn a lot about the legislative process. For example, I quickly learned that most legislators rarely have time for a lengthy or detailed legal analysis of your proposed amendment. As Jim pointed out, legislators have lots of issues and their time is often very limited. For a number of years thereafter, I had the good fortune to continue to work with this client's lobbyists on most of the major environmental and growth management laws enacted in Florida. I also began to do an increasing amount of legislative work for other clients of the firm, including a lot of work for a large soft drink company, the state's biggest juice manufacturer, and a major waste management firm. I also got to do a lot of work with very talented lawyer lobbyists in our firm and outside our firm, including Jim Doughton, who used to be a lawyer in our firm. All the while that I was doing this, I continued to practice law, often representing the same clients in related legal matters, usually with respect to licensing, permitting, enforcement, rulemaking, or other regulatory proceedings, including administrative litigation. Of course, there are other lawyers who devote most of their time to government consulting and related political matters and do not actively practice law in the traditional sense. I found that there are lots of benefits to being a lawyer in the legislative process. Some of these have been alluded to by the prior speakers, but there are definitely benefits to being a lawyer in this process. As I indicated, I got my start by being asked to review and provide advice regarding the effect of proposed legislation in an area of the law with which I was very familiar. The lawyer's ability to analyze statutes and provide advice to clients regarding the potential impact of proposed laws is a definite benefit, particularly in a highly complex or highly regulated area. Likewise, the oral advocacy and writing skills learned from legal training can be very useful in the legislative process. Writing skills can be especially important in carefully crafting legislation or amendments or talking points or the like. And the lawyer's understanding of the legal process itself is often helpful in addressing important legal issues often found in legislation, such as administrative and judicial remedies, burdens of persuasion, burdens or standards of proof, standards of review, and the like. Finally, it's almost a matter of self-defense to be a lawyer, as many of the committee staff that we deal with, and in fact a number of legislators are lawyers too, and they often have very detailed questions that are best answered by a lawyer. So what are perhaps some examples of how it's helpful to be a lawyer in the process? A lot of times lawyers are quick to see ways that their clients may benefit by changing the law. Sometimes it's enough to simply make subtle changes in the law that merely clarify the law to help the client with his future activities. Clients may come to you and have a question about what a particular law means, and there may even begin to be some litigation over that, and you say, gee, we can just, the legislature's meeting next month, we can, make some changes in that law to clarify it for everybody going forward. Other times, you may have a matter in litigation, and, it's not clear that the court's going to resolve it, in a fashion that's acceptable to either party, so you may even boldly suggest that the law be changed retroactively. Definitely being a lawyer is helpful if you're trying to convince a staff attorney at the legislature or a legislator that you can change the law and make it apply retroactively. More commonly, I think lawyers typically help clients identify potentially damaging bills and then draft amendments to minimize or eliminate those impacts, or help clients draft talking points that explain why proposals are good or bad. Being involved in the legislative process also can help your law practice. The obvious benefit is if you practice law in the same area as you do legislative work, it is really easy to keep up with changes in that area of the law, since you're often involved in writing it or being involved in the legislation that affects that area. For example, if you practice in a highly regulated area like insurance or tax or environmental, it's a lot easier to keep up with changes in the law if you're around the legislation as it's being developed. But from a more selfish and perhaps practice development standpoint, being involved in the legislative process is definitely a plus. Those lawyers who work on a particular bill or piece of legislation often are in the best position to be hired to represent clients who seek advice regarding compliance with that law. Who better to ask than people that helped write it? In many cases, legislation also requires an administrative agency to adopt implementing rules. Many of these implementing rules are more detailed and comprehensive than the legislation itself. Lawyers who are involved in the legislation frequently are also best suited to represent clients in these required rulemakings. For example, for the many years that I practiced environmental law, new environmental laws typically required numerous new rules and regulatory programs, and our clients frequently ask us to help them, work on those implementing rules and licensing requirements and the like. And even the most recently enacted medical marijuana bill, I noticed, requires administrative agencies to adopt rules. What are some of the disadvantages to being a lawyer in the legislative process? As Jim mentioned, time management can be a real challenge, particularly during the 60-day legislative session when the lawyer may be required to be at the Capitol on short notice or for extended periods of time. I'm sure we get no sympathy from our lawyer legislators who are definitely over the Capitol and away from home more than those of us who also practice law. But it clearly is a time management issue. And those of us who still practice law full-time likewise aren't able to spend as much time during the off-season developing relationships with legislators or being involved in the political campaigns. As Katie mentioned, these are important activities as well. Likewise, as Dan mentioned, some of the ethical obligations of a lawyer in the legislative process can also impose disadvantages as compared to our non-lawyer lobbyist friends who typically are not subject to the rules regulating the Florida bar, particularly those rules relating to conflicts of interest and confidentiality, which Dan discussed, as well as the rules restricting communications with persons represented by counsel. Conflicts, as Dan alluded to, can be especially challenging in the legislative arena, as unlike litigation, the various parties that are interested in a matter are not clearly listed on the style of the case at the beginning of the process, so you know who they are. It's not uncommon for interested parties to become involved in legislation throughout the process. For example, as the legislation changes, some people may become more or less interested. They may change their position on whether they're for a bill or against it. And it's oftentimes bills will pick up a variety of different provisions, and you may find yourself in a situation where you have a firm client who wants to pass a bill because of a favorable provision in that bill, and then some completely perhaps unrelated provision in the bill is opposed by another client who wants to kill the bill. Those can be particularly challenging situations for the lawyer and the ethical obligations imposed on lawyers. Finally, Nikki asked me to talk a few minutes about the differences between practicing with a law firm or a small lobbying shop. There clearly are benefits to both. A big law firm can certainly offer sort of built-in clients, if you will, clients of the firm that you represent on legal matters and the like, and often have substantial resources to provide assistance to the lawyer lobbyist. On the other hand, small lobbying shops offer more flexibility and certainly don't have near the challenges with conflicts of interest. Personally, I don't think you can go wrong with either platform, no matter which way you decide to go. With that, Nikki, I'll turn it back over to you.
Fantastic. Well, I appreciate it again, Larry, for all of your time. And if there's any questions for Larry, please feel free to either send them to me or to Larry directly. Thank you again. Moving on to our legislative panel. So you're all going to bear with me. We've got a whole bunch of great legislators who will be on this afternoon, and I'm going to try to briefly go through some of their bios and some of the things that they've been able to accomplish here in the state of Florida. We are first honored to have Senator David Simmons on the phone. First of all, happy birthday, Senator Simmons. David is a state senator of District 10 who is serving Seminole and Volusia counties. He took office first in November of 2010. David is a chair of the Senate Banking and Insurance Committee. David was a member of the Florida House of Representatives from 2000 to 2008. He graduated first in his class in mathematics from Tennessee Technological University in 1974. He earned his Juris Doctorate from Vanderbilt Law School. David is the financial manager partner of the Bobin, Knight, Simmons, Manzarek, and Neal LLP. He is a board certified by the Florida Bar, both in business litigation and civil trial. He is also board certified by the National Board of Trial Advocacy. Next we have on the phone is Senator Rob Bradley. Rob is a board certified of the Florida Bar as an expert in city, county, and local government. He's also the Florida Senator representing District 7, which includes all of Alachua, Bradford, and Clay counties. Rob is also the Senate Appropriations Subcommittee Chair of the Criminal and Civil Justice Committee. He is a fourth-generation Clay County native who graduated with a B.S. in the University of Florida in 1992 and a law degree from the University of Florida in 1996. For the past decade, as managing partner of Coplausis, Bradley, and Garrison, PA, Rob focused his career on representing local municipalities and political subdivisions. He currently serves as general counsel of the town of Orange Park, the city of Keystone Heights, and the Crossings Community Development District in Eagle Harbor. Rob has served on the Clay County Board of County Commissioners as vice chairman. He has also served on the Board of Trustees of the St. Johns River State College, the president of the Clay County Bar Association, and the board of directors for the Jacksonville Area Legal Aid. Next, introducing Representative Matt Gates. Matt represents District 4 and is an attorney with Keefe, Ankers, and Gordon Law Firm in Fort Walton Beach, where he practices business and open government law. Matt grew up in Okaloosa County and graduated from Niceville High School, where he won the Florida State Debate Championship. Matt went on to Florida State University and earned his law degree from the College of William & Mary. Matt was first elected into the House in 2010 and serves currently as the Criminal Justice Committee Chair. Jim Waldman, our next representative on the phone, was first elected to the Florida House in 2006 after serving nearly 10 years on the Coconut Creek City Commission. Representative Waldman is a graduate of the University of Florida and Nova Southeastern University Law School and has been practicing attorney for 25 years and presently serves as general counsel to Kaiser University. Representative Waldman is a Democratic floor leader and serves as Democratic ranking member on the Select Committee of Gaming, the Regulatory Affairs Committee, and the Rules and Calendar Committee. He is the current president of the National Council of Legislators from Gaming States. Next, we have Representative George Moritas, who is a partner of the law firm of Moritas, Kofer, Carney, and Moritas, where he practices primarily in the area of real estate, probate, and estate planning. Representative Moritas graduated first in his class from the University of Florida in 2002 and practices here in the state. Upon graduating from the United States Naval Academy with distinction, he served 7 years of active duty as the United States Navy submarine officer and as a lieutenant commander in the reserve. While on active duty, he was awarded with a Navy Commendation Medal and Navy Achievement Medal. He currently represents District 91 and was first elected in 2010. He serves as Vice Chair of the Finance and Tax Subcommittee and as Vice Chair of the Choice Innovation Subcommittee. And lastly, we have Representative Greg Stubbe, who proudly serves House District 73, which is parts of Sarasota and Manatee counties. Representative Stubbe attended the University of Florida, where he was inducted into the University of Florida Hall of Fame and as an undergraduate, and earned a BS with honors in animal science with a minor of agricultural law. Following his undergraduate studies, the representative attended U.S. Levin College of Law and earned his Juris Doctorate in 2003. After law school, Representative Stubbe enlisted in the U.S. Army and spent 1 year in the infantry and 3 years in the U.S. Army JAG Corps as a criminal trial counsel, Chief of Detainee Operations, Legal Assistant Attorney, and Administrative Law Attorney. He served as a captain in the JAG Corps during the Operation Iraqi Freedom. Representative Stubbe is an attorney with the Becker & Polikoff PA firm and works in the firm's government law and lobbying practice group and business litigation practice group. In the Florida House of Representatives, Representative Stubbe is Vice Chairman of the Business and Professional Relations Subcommittee and the Vice Chairman of the Health Innovation Subcommittee. Welcome, everyone. Thank you again for being on today.
Thank you.
We're going to first start off with Senator Simmons. Senator Simmons, can you tell our panelists today what is your greatest public policy achievement in your tenure?
Most likely it would be not the one that has made the greatest amount of news and publicity both nationwide and internationally, which is to be the main drafter of Stand Your Ground. In fact, although I consider that very important, and it certainly changed the way people across the nation have thought about the duty to flee and the right to defend yourself in your own home or where you have a right to be. But probably what I'm seeing is the extra hour a day, which I began working on in 2007, 2008 for those low-performing schools, because there are children who attend these low-performing schools, the oftentimes minorities and certainly impoverished individuals who, by the time they get behind in middle school, are the same ones when they get into high school, drop out, the same ones who are unemployed after they drop out, and the same ones who are filling up our prisons. And so in 2007 and 2008, I was able to get a pilot program pushed through when I was in the House to see if the extra hour a day of intensive reading for these children would make a difference. The results were dramatic. And then in 2012, I was able to push through the Senate and then with the help of the House, the requirement that those schools that are the 100 lowest performing schools in the state elementary schools would be required to provide an extra hour a day of intensive reading instruction for these children. The results came back as being not only significant, but in many instances dramatic. And so this last spring, we were able to, in the legislature, increase that to the 300 lowest performing schools. And so that's been a matter of great personal pride.
Thank you. Representative Gates, I'm going to give you a softball here. Is there a significant piece of legislation from the 2014 session that you believe will have a statewide impact?
Yeah, Senator Bradley and I got some weed to some sick kids.
You want to tell everybody a little bit more about what that is that you passed?
Sure. There seems to be evidence that a low THC form of marijuana that can't get anybody high and isn't any fun will have a significant impact on reducing seizures among children with intractable epilepsy. I think a Stanford University study indicated that 85% of kids with these intractable forms of epilepsy would see a 50 to 100% reduction in their seizure activity. And so Senator Bradley and I worked on that, and I think the governor is going to sign it any moment.
Fantastic. I actually did see, Matt, but I wanted you just also to touch on. I saw that this week the Supreme Court upheld something that you worked on last year, the Timely Justice Act. We've been talking about the last hour or so, how Tallahassee impacts the actual practice of law. Can you kind of show this as an example of some of the things that you looked at last year and how the Timely Justice Act may impact that?
Yeah, it's somewhat funny that this year Senator Bradley and I worked on legislation to let vulnerable people live longer, and last year my main priority was to make sure that some pretty heinous people did not live longer and were executed in a timely fashion. The Supreme Court yesterday upheld the Timely Justice Act, which says that if someone has a basis for an appeal, that basis has to be founded in a claim of actual innocence, that there can't be endless appeals based on things so there's not a claim of innocence, and also there is a good deal more transparency in which ripe to be executed. And those who make a living representing death row inmates appealed, saying that we were infringing upon the executive branch and on the judicial branch, which is something that we, as all of us, as legislators and particularly lawyer legislators, we like to make sure that we show a good amount of deference to the other branches of government, and in exchange we hope they show some deference to us. And I think that the court's opinion is a great exercise in mutual deference, where they acknowledge that we had appropriately threaded the needle to bring transparency to bear, to substantively change the law regarding what is a substantively appropriate appeal, while not telling the court how they have to adopt their procedures, and while not inappropriately abridging the right of the executive branch to have a robust clemency process. So for those of you who are separation of powers geeks, it's a pretty interesting opinion.
Thank you. Senator Bradley, kind of going off of what Representative Gates was just saying, do you think that there is a higher standard of our legislators who are actually attorneys?
Well, first of all, I think everybody gets a flavor of working with Representative Gates and why I always have so much fun working with him. He is a effective and colorful advocate for the causes that we share. But I will tell you, could you ask the question one more time?
Sure. I was asking if there is a higher standard for, those of you who are on this panel are all also attorneys and legislators, if there's a higher standard for you all since you actually are attorneys as well when it comes to your legislative responsibilities and priorities.
Well, I think that that's probably an individual decision by each senator and representative who's a lawyer. I will tell you that I certainly, when I look at proposed legislation or I consider what proposed legislation to advocate, I look at it through the lens of a lawyer. The tools that I learned in law school, the tools that I've learned as a practicing lawyer in analyzing things and presenting things. I certainly hope that the things that I've learned as a lawyer allow me to be a better senator, and I think that having that background is of particular help when one is serving the legislature.
Thank you. Representative Waldman, kind of off of that question, do you feel that being an attorney and a trial attorney has given you some additional skills that maybe your other colleagues in the legislature don't have?
Well, I'd like to think that it's just my superior knowledge to all of them. That
of course.
Now that I found out that Representative Moraitis graduated #1 at UF, I have to defer to him. But in all seriousness, I think that being a lawyer does give you a benefit over others in the legislature. I think certainly from the standpoint of being able to express your opinion, being able to analyze issues on all different sides and look at things that way certainly helps out. Many of our colleagues who are not lawyers do have a difficult time understanding the distinctions in the law and some of the language that's there and what, in fact, as Representative Gates would say, as the effect of one comma might have in a bill. So it is important to have that legal background, I believe.
Thank you. Representative Moraitis, kind of going off the same thing. Have anything that you have learned along the way that you would wish that you had knew on day one?
Well, thank you, Nikki, and I want to thank Representative Waldman for his compliments. A rare display of humility for such a wonderful man I enjoy working with. Things I would like to have known from before day one, that's a great question. I would say just kind of how the process works exactly. As you get into it, you start to, it's just like anything in life and just like being an attorney, you start to sort of understand, what can be done, what cannot be done, where can you make a difference, and what should you spend your time doing. I mean, I think we all have gone through that as attorneys. What is our proper role with our clients, with other parties, with other attorneys. And I would say just understanding how the process works more. I wasn't, I know Representative Gates and some of the others have been aides in the process, and so they had a much better working knowledge of how the system works and, frankly, how the political process works. So I would say understanding that a little bit more, how bills, we all take civics, but how does a bill become a law? Where really are the roadblocks, and who are the people who can help, and who are the people who are going to hurt you? So I would say understanding the process and your role in it.
Representative, maybe I'm going to ask this question. Anything that you wish that you would have known on day one, or lessons that you would be teaching your new colleagues that will be coming in during the 2015 session?
Did you say Stubbe or Simmons?
Stubbe.
Okay, sorry. I would echo what Representative Moraitis said. And that's one of the challenges with term limits is it takes you several years to kind of get your feet wet and really understand the process. One of the advantages that personally I had, my aide, talking about staff, she had worked with the prior representative for 8 years and the prior representative for him for 2 years. So she had 10 to 12 years experience coming in, with me hiring her into the process. And that, I can tell you, has paid huge dividends in the beginning. So it's nice to have staff that works for you that has been in the process a long time to help kind of guide you through the legislative process and the nuances within the chambers.
And Senator Simmons, to go back to you, how do you deal and manage your legal clients during session? And do the rest of your partners get frustrated when you go on a hiatus for 60 days?
Well,
and if you don't mind, we're hearing some feedback that if you can talk a little bit louder into the phone.
Okay, can you hear me better now?
A little bit.
All right. Probably my partners are frustrated with me all year long, maybe not even because of the legislature, but certainly being in the legislature, the Senate, it is very demanding as to your time. I can say to you that having been in the House for 8 years, from 2000 to 2008, and then taking 2 years off, and then being in the Senate from 2010 until the present, I've had the opportunity to watch some as attorneys, some as business people, that the halls of the legislature are littered with the carcasses and the bones of legislators who have come up there and have been unable to keep both their business going and their legislative practice going. And so it is difficult, and I advise people who run for office that they still have a life back in their district, and that it is incredibly important to not lose sight of it. I have seen legislators end up spending all of their time doing legislative things and watching their business or whatever else be significantly hurt. I will say this to you, that if you have partners in a law firm who are willing to understand, and they're good friends as well as good partners and good associates, they pick up the slack. They do a great job, and you can do a lot in the legislature with the help and the assistance of your partners. They've got to be understanding. They've got to be willing to be part of the team, and if that happens, it works out fine.
And Senator Bradley, how exactly do you balance your public duties in your practice?
Well, everything that David said is absolutely correct in terms of, if I could spend 60 or 70 hours a week on just Senate items and responsibilities, not just during session but out of session, because there is always another speech to give, there's always another meeting to take, and you just have to be very disciplined in setting your schedule. You have to make sure that I have 3 teenagers, you have to make sure your wife and kids, they're giving so much, and that they get the time that they deserve from you, and not just time, but your mental energy and your mental attention. And you have to have incredibly understanding business partners. My law partners have been wonderful. What you have to do is talk to people like David Simmons before you join this circus, because he has been a good friend in terms of trying to teach me and tell me how to balance these things, a good mentor in that respect. But I tell you, at the end of the day, there are not enough hours in the day to balance it all. And so at the end of the day, you have to have business partners who understand and accept that once you join the legislature, your ability to be there and be present is going to be diminished from what it was before. And just put that in the analysis when you make your decision whether to run or not, because that is the reality of things. But at the end of the day, you have to be disciplined to make sure that your family and your business is taken care of, because if that goes, this Senate stuff is a wonderful privilege, and it's a great honor to be able to do. But at the end of the day, it's not forever, and your family and your business is going to be there when you're done with your time in Tallahassee.
Representative Gates, do you think that you have a greater advantage over your colleagues since you have a both debate background and a legal background?
Yes, he does.
That's a rhetorical question.
Not nearly the advantage that Representative Waldman has. Now, look, I think that most of the things that people see on television are the debates and the conflicts, but I think everyone on the phone would acknowledge that that's not actually where most of the work gets done. Far more important than an ability to advocate for a position on the floor of the House or the Senate is an ability to sit down with colleagues and find common ground, because most of the challenges that we face in Tallahassee are in fact not partisan. Most of the challenges we face are how to determine, how to get government to work the right way. And as a committee chairman, for the first time these last couple of years, I found that the most important work I did was never the work with a microphone in my hand. It was the work sitting down with Republicans and Democrats and then leveraging all of the intellectual capital that we have to be able to achieve solutions to some very complex issues in a very complex state.
Representative Waldman, I'll kind of let you fall into after that. What's your take as far as, what Matt just said?
Well, I agree with him. First of all, let me just say, there is no question about it, but Matt is the best debater in the House and has been for a number of years that I've served with him, in spite of the fact that he's on the other side of the aisle from me, and it's always a challenge with him. But to the point of what he just said, he's 100% correct, and he is, I'd say, kind of in the minority relative to the participation of the other side, of the minority. We talked earlier about the Timely Justice Act. I will tell you that Representative Gates sought me out actually in the beginning when he was going forward with that, knowing that I was in opposition to it, but to hear what my input was, and he took it, and in some instances he took it, and some of the things we disagreed with. But it is important to work behind the scenes. Being on the floor is really just the show, and he's right. We get things done. Interestingly, of course, we get things done in a bipartisan fashion behind the scenes. In front of the cameras, everything's a lot more partisan.
Representative Stubbe, what do you think is the most frustrating part of the whole process?
Well, and
the senators and some of the other representatives have kind of already alluded to it. It's the challenge of balancing a professional career while also being in the legislature, I would say, is by far probably the biggest challenge that I have seen, especially being a younger member and a younger professional trying to also scrap a living together as a lawyer and being in the legislative process. So that's probably the biggest challenge that I've seen. I mean, the actual process, I love the process, and I love working with colleagues on both sides of the aisle, and I think that's the way the process should work. And quite frankly, I think Florida does it very well, especially in the House, as to how we work together.
Representative Moraitis, can you kind of talk through how you navigate the difference between policy and politics, and at the end of the day, which typically wins out in your view?
Yeah, I first want to acknowledge I'm one of Representative Gates' debate victims, so I want to first of all say that, and then also say, I was interesting because the now Lieutenant Governor, Lopez Cantera, actually kind of helped sit me down when I was first there. There's a courtesy office visit when he was the majority leader, and just said, I've seen people come up here and some of them are completely focused on policy and some of them are completely focused on politics. And of course, the good policy is what we're trying to produce, but he said you can't really take your eye off of politics entirely. And there is a balance there. I would say that, for the most part, the right policy is getting done. Does anything happen that's political? I mean, of course it does, because it's a political body and there's political interest. And when we say political, it just really represents the fact that, we have different viewpoints and different philosophies of what's supposed to happen. And so, sometimes what people consider political is really just the fact that people have legitimate differences of opinion. We had an election. There are certain numbers, in Democrat and Republican, and, sometimes what people call us political is really just what's happening as a result of an election and the philosophy that has the upper hand at that point in terms of numbers. I would say for the most part, though, I mean, there are the other politics I guess you could talk about would be occasionally you have, personality conflicts which can derail bills. Fortunately, I've not been, that's not been something I've been personally subjected to. And I would say, as a credit to the leadership I've been under Speaker Cannon and Speaker Weatherford, I really feel like a lot of that stuff went away, more so than, when it first showed up. It seemed like people were very sensitive to that. I feel like this past year especially, not so much. I mean, I didn't really see a lot of bills being derailed because of a personality conflict. So I think a lot of that's the leadership as far as that aspect of it. But, the good policy is what we're trying to produce, and I think Representative Gates and Representative Waldman both alluded to how you do that. It's kind of the behind-the-scenes bipartisan working together.
Representative Gates, knowing that this is an election year, how did that weigh on some of the decision-making process through the 2014 session? Were there any complications because of the fact that it was an election year? Were there certain policies that passed or failed with the 2014 in light?
Well, I think, Nikki, anytime there's an election year, it sharpens the rhetoric and it raises the stakes. You have to be very careful about the positions you take, but you also, as a Republican, a conservative Republican, I want to advance the cause of my party and of the views that I hold. And so there's more media attention, and so just the stakes are higher, and there's a greater amount of pressure to ensure that you're correct. You don't get caught in a misstatement or a mischaracterization. And likewise, you've got, I think, what will be a very competitive governor's race going on in this last legislative session. I think that many of the things that were done, if you look at the $500 million in taxes, fees that were reduced, a lot of that was flavored with a political dynamic, one way or the other. And, that's a healthy thing, because I think the more we can have substantive debates, the less we become overly reliant in our political dialogue on a glossy 5x9 mail piece or a slick 30-second commercial. So I actually enjoy election years because it gives you an opportunity to present contrasting views. And I would say there were several instances this last year where Representative Waldman and other Democratic colleagues scored some points and had some body blows, and we might have scored a few as well. But that's a great thing about a system that allows us to speak freely about the things we care about. And the great thing is that in this very diverse state, the voters will ultimately render a verdict on which political party has the most compelling narrative.
And Senator Bradley, just to go off of that, was there any pieces of legislation that you saw either passed or failed or were promoted due to the fact that it was election year?
Well, I was really hoping to get local government pension reform accomplished, and we were able to get it out of the Senate, and it did not get out of the House, and that got caught up in some larger pension debates between the two chambers, and so that, I think that would be an example of a policy where I think everyone probably agrees that the local pension effort was a worthwhile effort, but at the end of the day, it takes two to tango, and the Senate was not where the House wanted us to be on statewide pension reform, and therefore they exercised their right to speak on local government pension reform. And I don't know if that, I don't think that had anything to do with election year politics, but I do think that's an example of how political dynamics, which, by the way, I don't think are unhealthy. I think that's healthy because, like I said, the founding fathers, designed a system where it takes two to tango in the legislative branch. So I guess that's more of an example of politics versus policy in that discussion rather than election year politics. The election year, the governor's race certainly cast a shadow over the things that we did this year and colored a lot of the things that we accomplished.
And I guess just kind of to expand on your answer just now, can you explain to some of the participants kind of how the dynamics between the two chambers works as far as working together and crossing the aisles?
Well, you can have you can be the most effective senator in your own chamber in the world, but if you don't have a dance partner on the House side, then it doesn't matter. And I was fortunate to work with Representative Gates, not just on the medical cannabis bill, but he and I worked hard on a couple of other bills, including overhauling how our state deals with sexually violent predators. We had discovered through a lot of very awful, tragic incidents throughout the state of Florida that we had loopholes that needed to be closed in how we deal with sexually violent predators, and we, I think, effectively closed those loopholes. But we did so by sitting down, he and I, very early on and often to bridge any gaps we had between the two chambers. And when I just described a piece of legislation in a very broad term, there were a lot of details that were up in the air. There were times when we didn't agree, and not necessarily he and I, but our respective chambers, on the details of that legislation. And we needed to bridge those differences, and we did. And so, I think that if I notice anything, it's that sometimes folks have a tendency to just focus on their own chamber rather than focus early on what's going on the other side of the house. At the other side of the building, because you got to pass out of both houses.
Senator Simmons, you've seen your handful of legislators come and go since you first were elected into the Florida House. What have you seen as makes a successful legislator?
The important thing is to be able to maintain a moral compass, and there's so much pulling in so many different directions, and I think that just as Stephen Covey says in his book about the 7 Habits of Highly Effective People, the premise of anyone who is successful is character. You can't have any of the other things that he discusses without having character, and I have watched people who get buffeted by the winds of public opinion, and they're very frustrated. They take different positions. I've had lobbyists say to me, I'm just so pleased that whatever you tell me when I'm in your office is the way you end up voting on the floor of the Senate. And the fact of it is, I look at them and I say, well, what do you mean? That's not difficult. And they say, you don't know how many times someone tells me he's going or she's going to do a certain thing, and then they do it entirely differently on the floor of the Senate or the House. So my statement to you, what makes success, it first takes the ability to withstand the multiple tensions and efforts by others to pull you in different directions. But if you can navigate that and just remember that the first and foremost thing is to do the right thing, then the rest of it will take care of itself.
Thank you. Representative Waldman, as you are coming to the end of your tenure at the Florida House, any votes that you look back that you wish you could have changed?
That's got to be Gates laughing, I guess. I don't really think so. I think I voted much the way what Senator Simmons just said, and I did have the honor of serving with Senator Simmons for 2 years in the legislature, and he was one of those people who gave you their word and you could take it to the bank, and that is important. I just wanted to reiterate what he was saying. I think that's the most important thing about being successful. But I don't think there are any votes that I took that I wish I could change right now. The interesting thing about some of the votes, and this gets back to one of your questions before, and that's the politics of it. And I happen to be one of those people who believes that the politics far outweighs the policy. What happens is all of the agenda is set by the majority party. And so while we may agree on 90, 95% of the things, it's not the things that we are looking to make as a priority. So politics plays such a large role in all of it, and it does shape everything that goes on in the election years and all of those things. So I've been put in a position where, being in the minority party, I've taken positions that are contrary to the majority party, but you fall into that very comfortably after a while.
I like that. Representative Stubbe, how do you feel the lobbyist falls into the process? What role do they play?
That's a good question. I actually, lobbyists sometimes get very bad raps in the public, and especially with our constituents. But quite frankly, we as members cannot be intelligent on every issue that we deal with in the legislative process. And quite frankly, I rely upon lobbyists that I trust, that I know have subject matter expertise in a certain area, to come to me and give me information and educate me on bills that are coming before the legislature. So for me, as a legislator, I think that's the most important role that a lobbyist has for me, is if there's a certain area that they are advocating on behalf on, that they have subject matter expertise in or are very well educated in, educating me on what the appropriate course of action is. And a good lobbyist will tell you both sides. They're probably advocating for one side, but they'll tell you what the other side's arguments are, so you're educated on what the entire issue is to make an educated and informed decision. And good lobbyists do that very well, and I think that is, in my opinion, their role at the state level, to educate us on things that we specifically don't have subject matter expertise in.
And just to follow up with that, Representative Moraitis, has there been a time or a story that you can tell us without naming any names of any lobbyist who, through the process you've lost trust in, and if there's an example of something that you can share with the participants?
Well, I thought you were going to ask me for a positive reference like yourself or some of the other people we get to work with.
I will take positive or negative. I'll leave that up to you.
Okay. Let me just talk maybe positively. It'd be hard to kind of go back and think of something like that because, in the lobbyists, just to kind of echo on Representative Stubbe, I mean, the best ones are the ones that really, educate you. I think, of course, they're advocates, just like, as attorneys, we advocate for our position as well when we're representing clients. And so that's something that, as an attorney, it does help you to understand that when you have a lobbyist approach you, you may have a relationship with them, but they do have a position or an interest that they're advocating for, and you have to understand that. There's nothing wrong with that. You just have to understand that. And so I agree that, the better educated you are, and the good ones, like yourself and then like many others we work with, can be trusted. and we'll educate you on both sides of the issue. You know, I would have to say, just coming into the process, you know, for me, Pete Dunbar was excellent because I was asked to run the association bills, and you know, not having all the institutional knowledge of it, not having the relationships with, you know, with some of the people in the bar in the different sections, and frankly some of the members, it was extremely helpful in navigating through these bills, and a lot of getting these bills through. You can't just be, you know, by yourself or even with a few other members. You really need a lot of members. You know, as Senator Bradley said, you need both chambers. So you can be as effective as you can be in one chamber, but, you know, at some point, you know, you're not a member of the other chamber. And so I would just say the lobbyists really play a very valuable role. Our House staff plays a very valuable role for us in educating us as well. And I don't really have a story about somebody who's kind of let me down and we got torpedoed. I mean, I would say I knew it was coming. They were trying to beat me. It wasn't a secret when we lost a bill. You know, so I can't say it was because they were untrustworthy or devious about it. They were, you know, basically just able to prevail on it.
And Representative Gates, is there any pet peeves that you've, you know, in your tenure in the legislature that you've seen a lobbyist or a set of lobbyists do that, you know, really turn you off as far as, you know, the whole point of this, we have about 450 people on this call that are young in this process that we're trying to educate. So there are things that you would like to tell them of what not to do if they came to see you.
Well, I think that the quid pro quo is the most frustrating thing to many of us. I have had lobbyists, you know, sit in my office and they'll make their pitch just like we would make our pitch to a court in a judicial proceeding, and I'll let them know that I disagree with them, and then they'll take the time to remind me that they made contributions to my campaign account or knocked on doors in my district for me, and I find that extremely distasteful. And when people do that, as advocates in the legislative process, it's similar to a lawyer who doesn't respect the court or has a demeanor or behavior that is a reputation that lingers for quite some time. So the kind of quid pro quo part of politics is what I would say would be something that is a pet peeve of mine.
And Senator Bradley, just to kind of go off of what Representative Gage just mentioned, how do you see the role of fundraising in the legislative process?
If you're going to be elected to office, then it's a necessary part of our system. And so I look at it as it's not something that I relish necessarily or enjoy that much, but I also understand that in order to go into public service, there are certain things that you need to do. And not everything in life is easy. And so you accept that as a part of the things that you have to do in order to be in a position to be able to influence public policy in a positive way for your constituents. And so, you know, you do it, and I try to do it as cheerfully as possible. But I don't look at it. I look at it kind of as, you know, agnostically. It's not good or bad. It just is.
Representative Stubbe, anything during the 2014 session that you didn't get accomplished that you look forward to working for 2015?
Gosh, there's a lot of things that didn't make it through the process.
I want to give a gun to every teacher, Stubbe.
Yeah, for 2 years I've worked on a school safety bill that was able this year to actually get the support of the School Board Association, the School Administrators Association, and the Florida Sheriff's Association to also support. It passed the House. We were unable to get it through the Senate this year, so I'll continue to advocate for that. And then I vice chair Health Innovation, and I worked on the trauma care legislation, and I was also a prime sponsor of some recovery care suite legislation that also passed the House. And all of the health care related bills this year, for the most part, were put onto one big package bill and died. So those are things, and then the craft brewer legislation I also worked on. Also didn't make it through the process. So those are four big issues that were probably in papers statewide that I'll continue to probably advocate and work for next year.
And Senator Simmons, and what about yourself? Anything that you look forward to working on for the 2015 legislative session?
Certainly, this last spring and during last fall, 4 other senators and I began the heavy lift of enacting a comprehensive method of assuring that our springs across the state are cleaned up and preserved. And as many of you know, there has been a significant degradation in our springs. The springs are simply a window to our aquifer, the same water that many of us drink. And the fact of it is it's being degraded. And so we began the journey of passing legislation that would deal with the source of all of the potential manners by which there is the degradation of our aquifer and thus our springs. We passed 38-0 a bill that provides the template for doing that. It got hung up in the House, and I know that both the Speaker designate and the President designate have committed that water resources and the preservation of the quality of our waters, as well as the quantity of our waters here in the state of Florida, are going to be a major, major issue in the coming year. So I look forward to working on that in order to assure that there is a quality of life for all of us here in the state of Florida, not only for ourselves, but for our children and our children's children.
Thank you. Representative Walden, I know while you will not be part of the 2015 session, we had discussed earlier on this call, Larry Sellers and some others were discussing the gift ban. Can you kind of go through some of your thoughts as far as whether that was a positive impact on the legislative process, and if not, what changes would you recommend to those who were on this phone call to see changes made?
Yeah, the gift ban was put in place before I came into the legislature. It's not something I would have voted for. I think that what it's done is it's decreased the interaction between legislators after hours, where a lot of things, good things are discussed and things can be done as to what Representative Gates talked about earlier, behind-the-scenes type of information that you can get. The most important thing for legislators is to get information, and many times you can't get it sufficiently during the day, and sometimes just going out. I don't think that anybody who's getting a meal worth $10, $20, $50 is selling their vote. I think that goes back to what Senator Bradley was saying before. It's a necessary part of the process is raising money, but you have people on both sides of the issue. You have lobbyists who you socialize with who may be for an issue, and then those who are against it, and it doesn't really make a difference whether they bought you dinner or not. So if I were to stay in the legislature or looking forward to it, I would look to modify it. Certainly you don't want gifts being worth thousands and thousands of dollars, but a meal here or there, a bottle of water, a cup of coffee, I don't think that's buying anybody's vote. So I would hope that that's looked at in the next several years.
And Representative Gates, do you agree that the gift ban should be altered? And also, can you make some comments about your thoughts about any of the campaign fundraising reform, if there should be any legislation in future years?
Well, we just reformed the fundraising and campaign finance laws recently, so I think that we ought to let those reforms sink in before any sort of major overhaul. I actually disagree with my good friend Representative Waldman on the gift ban issue. I just don't. I'm happy to buy my own dinner, buy my own cup of coffee, as I know Representative Waldman is. And look, if I can recall correctly, Representative Waldman, even without the gift ban in place, you and I were able to find plenty of time after hours to get to know one another better, and certainly that's something that I appreciated. And I think that gift ban was so abused. I was a staff member in the legislature, and I would see legislators take their whole family and everybody they know back from their district out for a $1,400 dinner, and then they would point across the room and have somebody deliver the bill to a lobbyist. And that's the kind of stuff that makes people sick about the political process. And again, I know that's not what Representative Waldman is advocating for. I think he's suggesting a more modest reform, but I think that the pendulum swung so far towards having lobbyists supplement the lifestyles of legislators that it's probably a good thing to have us all pay for our own stuff.
But I'd like to, if I could, just jump in a little bit, Nikki, because the thing is, Representative Gates is right. He and I have been able to forge a friendship, and we have the ability financially, both of us, to go out and to pay for our own meals. But there are many legislators who don't have that ability. This is their only income that they have, and they can't go out in the evening after hours and get together with others, and it does become quite a drain on them. And I just to quickly just add, no, the question wasn't asked of me, but that gets to the issue of the young lawyers and the student debt that they have, and that's one of the things that the legislature, and my hope is that those members on the phone going forward will look at the bill that I had filed this past year and Senator Ehrenberg in years past that would give relief and loan forgiveness to those lawyers, young lawyers who go into the public sector as a state attorney or a public defender, capital collateral, regional counsel, or anything like that, so that they then can stay in there and we have the best and the brightest working in the public sector.
And Representative Waldman, I appreciate you bringing that up because earlier in the presentation, that bill was addressed by Jim Doughton. And so there was a question that had come up that I had promised that we would ask you when you came on. And that is, if there was a reason why the Assistant Attorney Generals were not included in the loan repayment bill, were included but not included in the retention pay in the budget. Are you aware?
No, I'm not.
Okay. Okay. I had promised. So well, I appreciate everyone's time today. That does conclude this segment of the presentation. If there's anybody who would like to make a 10-second closing remark, I certainly open it up to the phone.
Well, thank you, Nikki, for doing this.
Okay. Thank you, everyone, again. And that, again, concludes our presentation today. Just want to reiterate that this webinar will be located on the Young Lawyers website, which is www.flaYld.org. And you can also go onto that website for regular announcements, such as mentoring with the Master Pros, past webinars, and you can also follow the YLD on our Facebook and Twitter and LinkedIn accounts. And again, the course number is 1404259N. Thank you again for your time, and look forward to future presentations. Have a great day.
You will now be disconnected by the leader.